Hi everyone, welcome back to Let's Talk Legal with Karimi Chege. My name is Karimi Chege, an advocate of the High Court of Kenya and your go-to employment expert. This is Season 1, Episode 4 of Employment Law Unlocked, where we'll be talking about discrimination on the grounds of pregnancy. This is a continuation from Episode 3, where we talked about the right to maternity leave. So if you have not watched Episode 3, I highly recommend that you pause this video right here and proceed to watch Episode 3 so that you can understand how we got here. So what are the objectives of today's episode? 1, we will be defining discrimination just in a layman's language. 2, we will outline the constitutional and statutory provisions that protect a female employee from discrimination on the grounds of pregnancy. And 3, in the event where a case has been lodged on discrimination on the grounds of pregnancy, who bears the burden of proof? So let's get straight into the episode. So what is discrimination? Discrimination, in a very layman's language, is unfair treatment based on who you are rather than your performance or your qualification. So this could be unfair treatment based on your gender, your age, your marital status, and in this case, pregnancy. Now let us talk about the constitutional and statutory provisions that protect you as a female employee from discrimination on the grounds of pregnancy. A female employee who is pregnant is highly protected under law. Article 27(4) of the Constitution of Kenya 2010, the highest law of the land, indicates that no one is to be discriminated either directly or indirectly on the grounds of pregnancy. This is echoed under Section 5(3) of the Employment Act, which prohibits an employer from discriminating against his or her employee on the grounds of pregnancy. Further, under Section 46A of the Employment Act, it provides that if an employer proceeds to terminate his or her employee on the grounds of pregnancy, such a termination will be deemed unlawful. We can also look at Article 28 of the Constitution of Kenya, which provides that every person has inherent dignity and the right to have such right protected and respected. So I would like to pose a question at this juncture. Is it possible for a female employee to be terminated on the grounds of pregnancy? The answer is no. However, in the event that an employer proceeds to terminate the employment of his or her employee on the grounds of pregnancy, such a termination will be deemed unlawful. Now let us talk about the event where a case has already been lodged for discrimination on the grounds of pregnancy. Who bears the burden of proof? The law provides that a female employee is the one who bears the initial burden of proving prima facie discrimination. Prima facie discrimination just means that the employee needs to provide the court with a credible case of discrimination on face value. How does the employee discharge this burden? 1, they have to establish that they belong to a protected class, being that they are pregnant. 2, the employee needs to demonstrate that they qualified for the job that they have lost. This could be demonstrating that you successfully passed probation, you were absorbed into the company, and there have been no cases of your underperformance up until you became pregnant. 3, the employee needs to demonstrate that they have suffered an adverse employment action. And 4, the employee needs to provide a nexus between the adverse employment action and their pregnancy. Thereafter, once an employee has been able to prove all these conditions and establish a prima facie discrimination, the burden shifts to the employer under Section 5(7) of the Employment Act to disprove allegations of discrimination on the grounds of pregnancy. Now let us talk about the case of Christine Wanjira versus Computer Learning Center. In this case, Christine was employed as a sales accounts manager in January 2019 and was to receive a gross salary of 91,947 shillings. On 7th of August 2019, Christine notified her employer via email that she intended to proceed on maternity leave. Thereafter, on 8th of August 2019, Christine took sick off due to a complication that had arisen out of her pregnancy, and thereafter proceeded on maternity leave. Upon receiving Christine's notice of her intention to proceed on maternity leave, the employer wrote a letter placing Christine on performance improvement plan and only issued this letter to Christine on 13th of August 2019 via WhatsApp while she was still on maternity leave. According to her employer, Christine did not improve in her performance, and the employer proceeded to terminate her employment on the grounds of poor performance on 19th of August 2019. These are just 6 days from the date when the employer had placed Christine on performance improvement plan. So the court was faced with the decision of establishing whether Christine's termination was linked to her pregnancy. The court noted that the timing of Christine's issuance or placement on PIP, that was on 13th of August 2019, and the timing of her termination, that is 19th of August 2019, did not indicate any good faith on the part of the employer, because on these two dates, Christine had already proceeded on maternity leave. The court also noted that there is no way that the employer expected Christine to improve on her performance while she was on maternity leave. The court also noted that the employer had not provided the court with any evidence to prove that Christine was underperforming before she notified the employer of her intention to proceed on maternity leave. Further, the court was persuaded by a witness that had been called by Christine, was of the name Sophia, who was a former employee of Computer Learning Center, and Sophia testified that she had been terminated by the employer on the same grounds of poor performance immediately the employer noticed that she was pregnant. Sophia's testimony was corroborated by the email by the human resource manager of the employer by the name Emily, who had warned the employer for repeating the same mistake that they did with Sophia, now with Christine, which was to terminate Christine's employment immediately she proceeded on maternity leave. Therefore, the court found that Christine had indeed been discriminated on the grounds of pregnancy, and that the employer had violated Christine's rights under Article 27(4) of the Constitution of Kenya and Section 5(3) of the Employment Act. This necessitated the court to award Christine the sum of 3 million as general damages. So what can we learn from this case? A female employee who is pregnant is highly protected under law. In the event that you are discriminated on the grounds of pregnancy as an employee, you bear the burden of proving a prima facie discrimination. Once you do so, the burden thereafter shifts upon the employer to discredit such allegations of discrimination. In the case of Christine versus Computer Learning Center, the employer was unable to disprove allegations of discrimination due to the fact that there was an email by the human resource manager of the employer. In the event that as an employer you are unable to disprove allegations of discrimination, your employee will be entitled to damages for discrimination on the grounds of pregnancy, as we have seen in the case of Christine. That marks the end of episode 4 of Employment Law Unlocked, but stick around for episode 5, where we talk about the other benefits under the Employment Act. You do not want to miss this. Thank you so much for watching, and see you on the next one. Remember, information is power, legal knowledge is freedom.